I'm Drew Stevenson. This is for my administrative law class. This is about bimetallic investment company versus the State Board of Equalization. This is a 1915 case from the U.S. Supreme Court. We study it as a companion case to Londoner v. Denver, and they're always cited together. In modern times, both cases are about property tax increases and protests over that. And both come from Colorado and both went to the U.S. Supreme Court. Together, the two cases sort of carved out an area of doctrine or doctrinal law and administrative law about when a party that receives a negative or adverse decision from a government agency has a right to an in-person adjudication or hearing with the agency before the decision becomes final. The other thing that's interesting about this pair of cases is they're two of the only cases in our course that are not about federal agencies or federal officials doing something. These are both from the state or local level. So let's dive in. In the early 1900s, the state of Colorado, through its State Board of Equalization and its tax commission, issued an order that there should be a 40% increase across the board in the tax valuations of all properties in the city of Denver. In other words, this is the tax appraisal values were supposed to be adjusted up by 40%. If you've just finished studying Londoner v. Denver from 7 years before this case, when they were paving the streets of Denver, it sounds like that really improved the property values. In any case, so everyone's appraisal value for purposes of property tax is going to go up. Bimetallic Investment Company, or BMI, owned a lot of properties in the city of Denver, and so they brought a challenge to this because it was going to affect them. So Bimetallic sued in federal court saying that they were denied due process under the 14th Amendment because their property values were affected and they were being subjected to higher taxes, property taxes, without an opportunity to be heard. And the state court dismissed the complaint. So the legal question that's before the Supreme Court in this case is whether there's really a constitutional right to be heard for everyone whose property taxes are going up if everyone's property taxes are going up by the same percentage in a certain year, because that's the situation in this case. In other words, does due process require that everyone get an individual hearing to protest the increase in the tax valuations of their property? The U.S. Supreme Court basically affirmed the dismissal from the Colorado State Supreme Court. Oliver Wendell Holmes wrote the opinion for the majority and basically said that there is no right to an individualized hearing. There's no due process violation here for something that a government agency does that really is a policy or a rule of general applicability, something that affects everyone. I pulled out a quote for those of you who like to underline in your casebook that I think is kind of the crux of the majority opinion by Justice Holmes. The question then is whether all individuals have a constitutional right to be heard before a matter can be decided in which all are equally concerned. Justice Holmes said, "Where a rule of conduct applies to more than a few people, it is impracticable that everyone should have a direct voice in its adoption." He basically says that taxpayers as voters already exercise power over the officials that are making decisions like these that basically affect everyone the same. He also gives an analogy to if the state had just increased the tax rate from, let's say, 15% to 17% or 20%, they effectively did the same thing by increasing everyone's tax valuations for their property or tax appraisal values by a set percentage that applied to everyone the same. Now, they have to distinguish here Londoner v. Denver, which is probably why the plaintiffs thought that they had a chance to win this case. 7 years earlier, the same Supreme Court in the Londoner case had held that the plaintiffs did have a right to hearings in a property tax increase or assessment. So the majority here points out that there's some key differences. This involves Londoner involved a relatively small number of people or plaintiffs that were affected, basically the people on the street that had been paved, as opposed to here where it's the entire city of Denver. Everyone's property taxes are going up, at least their valuation, by the same amount. And he also says that those few people were affected in an exceptional way based on individual grounds, right? It was based on the types of properties and who was the property owner and so forth. And that's different in this case, where it was just a broad categorical rule of general applicability. So where does this leave us? Well, this case by Metallic really clarifies that general agency rulemaking is more analogous to legislative action, and the safeguards are really political, right? The political accountability of the executive branch, and so individualized hearings are not constitutionally required. So our key takeaway here is that when an agency does something that looks more adjudicatory, basically it affects a small number of people in a specific way on individual grounds, it's going to require prior notice and some sort of individualized hearing, like in London v. Denver. But if the action is more quasi-legislative or is just rulemaking, then it affects a large number of people, and there's no in-person hearings required. So I have a diagram here that I show in a couple of my other videos about this pair of cases and this principle of adjudication versus legislative type actions from agencies. And basically, if you're having trouble sorting this out, hopefully this will help. Legislative actions generally are prospective. So when an agency does something, and I'm not talking about what the legislature does, I mean, when the agency does something that kind of looks more legislative, in other words, we're going to call it rulemaking, it's usually forward-looking. It's going to apply to the future and change the circumstances. It's a policy change. And it's a rule of general applicability. It's going to apply to everyone the same. And whatever facts were the basis for this are general policy determinations about societal problems or economic impacts or things like that. Adjudicative actions by the agency are agency decisions that are, in some sense, more retrospective. They're kind of asking who, what, where, when, how, what happened, and they have an individualized effect. So there's one person who's going to be uniquely affected by this, or a small number of parties who will be uniquely affected by it. So both are types of agency decision-making and policy implementation. But in one case, they're making a general rule or adopting a general policy. And in the other case, they're kind of making a decision about you or some individual. Your casebook authors explain right after this case in a note that, quote, that the concepts of judicial and legislative government action that are evident in the Londoner case and by Metallic really crystallized during the New Deal era into the modern concepts of adjudication and rulemaking. The court wasn't quite using the same terminology yet in those two cases, but our modern kind of dichotomy of legislation, of rulemaking and adjudication are derived from this pair of cases. Congress codified this development when it enacted the Administrative Procedure Act in 1946, which defines adjudication and rulemaking as two mutually exclusive types of agency action. And that concludes our discussion of the case Bimetallic Investment Company versus the State Board of Equalization.